Hey, what if I told you that the most important part of a lawsuit is the part you never, ever see on TV? Yeah, forget all those dramatic courtroom showdowns. We're going to dive into the hidden strategic journey that happens long before a trial even gets close to starting. And trust me, this is where cases are truly won and lost.
So, when you picture a lawsuit, you're probably thinking of lawyers shouting, "Objection," in a packed courtroom, right? Well, that's just the tip of the iceberg. The real fight, where all the strategy and most of the conflict happens, is a super-structured process called pretrial procedure. Honestly, this is the main event, and we're going to break it all down for you.
To make all this a bit more real, let's follow a simple case study. Let's call it the case of the exploding gadget. So imagine Paula plaintiff gets injured when a brand new gadget from Delta Corp just explodes. Paula obviously decides to sue. This simple story is going to be our guide through the whole process.
Okay, so how does Paula's injury actually turn into an official lawsuit? It's not as simple as just pointing a finger and making an accusation. It all kicks off by following a very precise set of rules and filing some really crucial documents. It all begins with 3 critical opening moves. First, Paula's lawyer files a document called a complaint. This is a huge deal. It officially starts the lawsuit and, more importantly, it stops the clock on any statute of limitations. Second, Delta Corp is formally served with that complaint. Now they're on notice. They can't just ignore it. And finally, Delta Corp has to file their answer.
So what's actually in a complaint? You might be surprised. It's not some long, complicated legal argument. It really only needs 3 basic things. First, a reason why this specific court has the power to hear the case. That's called jurisdiction. Second, a short and plain statement of the facts. The gadget exploded, Paula got hurt. And third, what Paula's asking for. In this case, probably money to cover her injuries.
The second Delta Corp gets served, a 21-day clock starts ticking. They have to file their answer, and in it, they go through Paula's claims one by one and either admit to them, deny them, or say they don't have enough information. This is also their big chance to raise what are called affirmative defenses, which is basically them saying, hey, even if what Paula says is true, we still shouldn't be held liable, and here's why.
Now, a simple one-on-one case like this can get a lot more complicated really fast. The rules are actually designed to bring all the related people and all the related claims into a single lawsuit, just to get everything handled at once. So, how does a simple case get bigger?
Well, for instance, what if Delta Corp claims that Paula misused the gadget and actually damaged their brand? They can file a counterclaim. They're basically suing her right back. Or let's say Delta Corp thinks a faulty battery came from another company. They can then file a cross-claim against that supplier, pulling them into the fight. Think of it as suing sideways.
This whole process of adding more people and more claims to the lawsuit is governed by rules called joinder. And the idea behind it is pretty simple: efficiency. The court wants to resolve every single dispute related to that one exploding gadget in one big, comprehensive lawsuit instead of having a dozen separate ones.
Now, what if that gadget didn't just injure Paula, but thousands of people? That's where class actions come into play. Instead of thousands of individual lawsuits clogging up the courts, a few representatives can sue on behalf of the entire group as long as they all share a common issue.
Okay, so the lawsuit is filed and all the players are on the board. What happens next? Well, we enter what is often the longest and, frankly, the most critical phase of the whole thing: discovery. You can think of it as the show your cards phase. Both sides are pretty much required to share all the evidence they have. The goal here? No surprises at trial.
The whole point of discovery is transparency, but it's not a total free-for-all. For any information to be discoverable, it has to pass 3 key tests. First, is it relevant to the case? Second, is it legally privileged, like a secret conversation with your lawyer? And third, is the request proportional, meaning you can't ask for a mountain of data for a case that's just a molehill.
Lawyers have a whole toolkit for discovery. A deposition lets them question someone live, under oath, to see how they'll perform. Interrogatories are written questions sent to the other party to lock them into an official answer. Requests to produce are how you get the real goods: emails, reports, the actual gadget. And requests for admission are a clever way to narrow the fight by forcing the other side to just admit to facts that aren't really in dispute.
But there is one major exception to this whole transparency rule. A lawyer's private thoughts, their strategies, their notes, what's called their work product, that is protected. And this is absolutely essential because it allows each side to prepare their case and develop a game plan without having to show their hand to the other team.
After discovery wraps up,
The case enters a phase of really intense management. Before a trial can even get on the calendar, the judge and the lawyers have to run this kind of pre-trial gauntlet, which is designed to streamline the case and figure out what will actually be argued in court.
A key part of this is the pre-trial conference. This is where the judge gets the lawyers in a room to get the case organized. They'll set deadlines, finalize witness lists, and, maybe most importantly, push both sides to seriously consider a settlement. You see, courts would much rather have cases get resolved without a long, expensive trial.
And that push for settlement, it really works. Which brings us to this staggering number. Over 90% of civil cases in the U.S. federal system never go to trial. They're resolved beforehand, either because the two sides reach an agreement or because a judge ends the case early with a pretrial ruling.
But what about that rare case that does go to trial and gets a final judgment? Well, this brings us to a fundamental concept of our legal system, finality. You basically get just one shot, one bite at the apple to argue your case.
So if you lose, can you just file a new lawsuit and try again? The answer is a hard no. You can't just have a do-over. And that's thanks to a powerful legal doctrine called preclusion, which is designed to stop endless lawsuits over the exact same dispute. And it comes in two main flavors.
Okay, let's break these down. First, you've got res judicata, or claim preclusion. Think of this as locking the whole box. Once there's a final judgment on Paula's entire claim against Delta Corp, that claim is done. It's over. Forever. She can never sue them for that exploding gadget again. Then there's collateral estoppel, or issue preclusion. This is more like locking a single puzzle piece. It stops a specific fact that was decided in the first trial, like, say, the battery was defective, from ever being argued again in any future case.
And why are these rules so incredibly important? Well, they're pretty much the bedrock of a stable justice system. Without preclusion, no judgment would ever be final. The losing side could just sue again and again, trapping people in endless legal battles and completely overwhelming the courts. It ensures that when a case is over, it is truly over.
So, as we've seen, the real work of a lawsuit is a total marathon, not a sprint to the courtroom. It's this highly structured process of filing documents, joining parties, digging up evidence, and narrowing down the issues, all governed by a complex but, well, a logical set of rules.
Which leaves us with one last big question to think about. Imagine a legal system with none of these pretrial rules. Would it be faster? Yeah, maybe. But would it be fair? See, the complex structure we've just walked through isn't just bureaucracy for bureaucracy's sake. It's a system designed to make sure that if a case ever does reach a trial, the fight is focused, the facts are known, and the battle is over what truly matters.